No, that's why I'm here.
Oh, I see.
You see, that's
I
how-
got you, Paul.
What's going on here?
A little backwash. Yeah, that's it.
I do. All rise. Court is now in session. Honorable Peter J. Corrigan presiding.
Please be seated. All right, good morning. It's my duty at this time to advise you of your constitutional rights. These instructions are important. Please listen carefully. Under the constitutions of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. These are: 1, the right to know and understand the charges against you; 2, the right to a speedy trial; 3, the right to a trial by jury. You may waive or give up that right and have your case tried by a judge without a jury. 4, at trial, the state of Ohio has a burden to prove your guilt by evidence beyond a reasonable doubt. 5, the right to meet your accusers face to face and to cross-examine the witnesses for the prosecution. 6, the right to summon or subpoena witnesses on your behalf. You do not have to testify against yourself. 7, the right to counsel. If you're unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you are unable to pay this fee. At the end of your case, you may be ordered to pay the assigned counsel fees if your judge determines you are financially able. If you choose to hire your own attorney, you have a right to a reasonable continuance to hire one. This morning, you are not here for the trial of your case. You are here for your arraignment. An arraignment is your opportunity to be informed of the charges against you, for bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statement made may be used against you. As your name is called, please step forward. You'll be asked when you received a copy of your indictment or information, and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive the 24-hour notice and we will complete your arraignment this morning. If your case is going forward by information, I will ask your attorney to place on the record that they discussed with you waiving the presentment of your case to the grand jury. You'll be asked if you understand the charges against you, if you knowingly and willingly sign the waiver, if you consent that the charges proceed by information instead of indictment, and if you wish to continue to be arraigned by waiving the 24-hour notice and reading of the information. You will be asked how you plead. A defendant may plead not guilty by reason of insanity, guilty, or with the consent of the court, no contest. If you want to plead guilty and you do not have a lawyer, the court will assign counsel for you so you may have a full understanding of your constitutional rights. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with a crime of violence and or any drug offense, under Ohio law, you cannot knowingly have, carry, or use a firearm or dangerous ordinance until your case is concluded. This is called being under a disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges you've been arraigned for today. Even if you have a CCW permit, you are still under a disability until your case is over. In fact, upon indictment, the sheriff who issued the permit shall suspend it until your case is over. Finally, if you are over 18 and have not provided a DNA specimen since 2011, You may be required to submit one within 24 hours of your arraignment. Inmates in the county jail have the right to be present in the courtroom. Do any of you want to be in the courtroom?
We're okay here, Your Honor.
Thank you.
We'll start one in the courtroom. First appearance, case number 686122, Louise Vargas, last name Varajas. Case going directly to grand jury.
Morning, Your Honor.
Good morning.
Frank Triazzi with the Public Defender's Office on behalf of Ms. Barajas.
All right. Before we begin, let me swear in the interpreter. Could you state your name for the record, please, sir?
Yes, Your Honor, my name is Robert Forstad.
Please raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially from the source language into the target language, using your best skills and judgment in accordance with the standards prescribed by law and the code of ethics, the court interpreters, follow all official guidelines established by this court for legal interpreting or translating and discharge all of these solemn duties and obligations of legal interpretation and translation, so help you God?
I do.
Please proceed.
Thank you, Your Honor. We're requesting that counsel be appointed to represent Mr. Barajas in regarding bond. Mr. Barajas is 76 years old, resident of Elyria. He has been a priest for 40 years and would just like to highlight Mr. Barajas has no criminal history to speak of, nothing violent, no felony convictions, and I'm afraid he won't be able to afford a very high cash bond. He does collect Social Security. We are asking the court take that into consideration for bond.
Your Honor, Brendan Mankin for the state of Ohio. The state is asking for the bond to remain at $500,000 as set by the municipal court. The defendant had formed a relationship with the victim's family. The victim is a juvenile 15-year-old female, and the defendant is transient in that he was from New York and was here staying with a friend. Thank you. And GPS, Your Honor.
All right, of course, consider this information. I'm going to accept the not guilty plea. Find us at $250,000 cash and surety property. No contact with victim. Temporary protection order is continued. Also, GPS, home detention monitoring. We will. I will assign Attorney Oscar Rodriguez to represent Mr. Barajas. Case will be assigned to the docket. I'm sorry, it's going directly to the grand jury. So there's no plea. It's the first appearance I've called this.
Can't I speak?
Yes, talk to your lawyer before you speak.
Sí, mira,
Yo prefiero que no diga nada.
no, yo sí voy a decir porque yo tengo que hablar.
I want to say something.
Sí. Bueno, yo soy sacerdote y la familia me invitó a orar por ellos.
I'm a priest and the family invited me here
¿Sí? A orar por ellos.
to speak.
Y yo oré por todos ellos y les ungí con el aceite. Y posiblemente ella me dijo que...
And I prayed with them, I prayed for them, and I anointed them with oil.
Y entonces, para no embarrarle la ropa, pues yo le puse la mano por ahí.
¿Cómo,
Y después, yo la ungí con aceite acá y luego...
I
pues, sí,
rubbed oil on them.
sí,
No vamos a entrar en los detalles de su
sí,
caso.
bueno, sí.
Okay. Va a quedar en hacerlo posteriormente.
Thank you.
Tú lo dijiste, ¿no? Tú lo dijiste. Tú le dijiste eso a él. No.
So that's it? That's what you said?